There's a legal defense strategy that becomes visible when the facts are indefensible. You stop arguing about what your client did and start arguing about whether the person investigating them had the right to investigate in the first place. It's not a defense based on innocence. It's a defense based on procedure, jurisdiction, authority, anything except the actual evidence. On a date in early 2025, the House Judiciary Committee held a hearing with a special counsel who investigated Donald Trump's actions on January 6th. What became clear during questioning wasn't that Republicans disputed the evidence. It's that they had shifted to a different argument entirely, that the prosecutor shouldn't have been appointed, that the investigation was illegitimate, that the process was flawed, the evidence largely unaddressed. One representative used her time to make that pattern explicit and to force the special counsel to state on the record what the investigation had concluded about Trump's guilt. Watch how she framed it.
Today, it seems like the Republicans have not really fought very much about whether or not Trump was guilty or not. In fact, their fight seems to be over whether or not you were authorized to prove their guilt. Do you recall a number of Republican members asking about whether or not your appointment was okay, even though we know that you've testified about the more than 100-year precedent that allowed for your appointment?
I was asked questions about that today, and our position, as we filed in our appeal, is that there was strong support for my appointment, including Supreme Court precedent directly on point.
Thank you so much. Additionally, everybody's been all gingerly here today, but I don't know why we're acting surprised that a man who had close to 90 allegations out of 4 different jurisdictions and ultimately ended up with 34 convictions after a jury was able to hear all the evidence would possibly be committing a criminal act on January 6th. In fact, considering the fact that we are now under the impression that he is violating people's due process rights, he is ignoring court orders, he's starting wars without congressional authority in contradiction to the Constitution. He's enriching himself to the tune of over $1.4 billion. He's shaking down electeds to draw maps that will help him stay in power because the Republicans don't understand that they swore an oath to the Constitution and that we are supposed to do checks and balances. He's also shaking down TV stations to get money. So why are we trying to pretend as if it is out of the realm for this particular man to commit the crime that he committed on January 6th, and frankly, the only reason he ran for president was to make sure that he would not be prosecuted, because I fully believe that you would have put him under the jail based on our long-form conversation that we had. But according to your special counsel report on page 137, it states the department's view that the Constitution prohibits the continued indictment and prosecution of a president is categorical and does not turn on the gravity of the crimes charged, the strength of the government's proof, or the merits of the prosecution. And that, quote, but for Mr. Trump's election and imminent return to the presidency, the office assessed that the admissible evidence was sufficient to obtain and sustain a conviction at trial. In other words, Donald Trump ran for president, like I said, so he wouldn't have to spend the rest of his life in prison. The chairman and other members of this committee have spent all day attacking you and trying to rewrite the history of January 6th. But Mr. Jim Jordan, the chairman, failed to mention how he was running around the Capitol terrified by the possibility that all those insurrectionists would harm him. In fact, on page 97 of the deposition transcript, you mentioned how Mark Meadows, the president's chief of staff, quote unquote, never saw Jim Jordan so scared.
The representative opens by naming the defense strategy explicitly. Republicans aren't arguing Trump is innocent. They're arguing the prosecutor shouldn't have been allowed to investigate. That's a significant tell. When you have the facts, you argue the facts. When you don't, you argue jurisdiction, procedure, appointment authority, anything to avoid discussing what the evidence shows. Then she cites the special counsel report directly. Page 137, the critical passage, the office assessed that the admissible evidence was sufficient to obtain and sustain a conviction at trial. That's the legal standard, not probably sufficient, not arguably sufficient. Sufficient to obtain and sustain a conviction. The only reason the prosecution didn't proceed was the Department of Justice's position that a sitting president cannot be indicted. That constitutional prohibition is categorical according to the DOJ. It doesn't matter how serious the crime is. It doesn't matter how strong the evidence is. A sitting president cannot be prosecuted while in office, which means Trump's reelection didn't exonerate him, it immunized him. The representative states this plainly. Donald Trump ran for president so he wouldn't have to spend the rest of his life in prison. That's not hyperbole if the special counsel's assessment is accurate. The evidence was sufficient for conviction. The only variable that changed was Trump's election. Then comes the detail about Jim Jordan. According to the representative, page 97 of a deposition transcript contains testimony from Mark Meadows, Trump's chief of staff, stating that he never saw Jim Jordan so scared on January 6th. The representative also mentions that Jordan's phone records were subpoenaed during the investigation. The Department of Justice subpoenaed Jordan's personal phone records in 2022, seeking data covering more than 2 years, reaching back to January 1st, 2020. So the chairman of the committee investigating the investigator was himself investigated. His phone records were relevant enough to subpoena, and now he's using his position to attack the legitimacy of the investigation rather than address the evidence it uncovered. The representative then pivots to establishing basic facts. Watch what happens when she forces yes or no answers.
So let's talk about facts. Donald Trump lost to Joe Biden, yes or no?
That's correct.
Okay. In fact, 60 federal and state courts have found that there was no evidence of election fraud. Trump's own attorney general and vice president knew that he lost the election, but he still tried to steal the election by pressuring state officials, designing fake elector plans, nearly having Mike Pence hanged, and ultimately demanding that his supporters, quote, fight like hell, correct?
Correct.
We all saw it happen we all saw what happened once they reached the U.S. Capitol. As your report outlines, President Trump knew that he would incite violence at the Capitol that day. In fact, some of Trump's senior advisors were pushing for violence. For example, page 81 of the report details how co-conspirators number 2, John Eastman, tried to convince Mike Pence to break the law, stating that, quote, violence was necessary. So it isn't just Trump who was responsible for the death of multiple law enforcement officers and the injuries of thousands of people. A lot of Republican members of Congress are also responsible. 147 Republicans voted to overturn the 2020 election results, including multiple members currently serving on this committee.
The representative walks through the factual record step by step, getting the special counsel to confirm each element on the record. Trump lost. 60 courts found no evidence of fraud. Judges appointed by Republicans and Democrats by Trump himself heard the evidence and issued detailed rulings. They looked and found the claims didn't hold up. Trump's own attorney general and vice president knew he lost. He tried to overturn the election anyway. Then she cites page 81 of the special counsel report. John Eastman, identified as co-conspirator number 2, told Mike Pence that violence was necessary. That's not a claim about what happened spontaneously. That's evidence that Trump's advisors were advocating for violence as a strategy to prevent the certification of the election. According to the federal indictment, when Eastman was told his plan would cause riots in the streets, he responded that there had previously been points in the nation's history where violence was necessary to protect the republic. John Eastman is a lawyer. He was advising the president and vice president on legal strategy, and according to the special counsel report, his advice included the assessment that violence was necessary to achieve their goal. Then comes the final point. 147 Republicans voted to overturn the 2020 election results, even after the attack on the Capitol. That vote happened on the night of January 6th, after law enforcement had cleared the building, after members had been evacuated, after the violence had been broadcast live. Across the objections for Arizona and Pennsylvania, a total of 147 Republicans in Congress, 8 senators, and 139 representatives voted to sustain one or both objections. The representative notes that some of those 147 Republicans are currently serving on the committee conducting this hearing, which means members who participated in the effort to overturn the election are now investigating the investigator who documented that effort. That's the pattern she's highlighting. The people who were involved are now positioned to attack the process that investigated their involvement. Jim Jordan's phone records were relevant to the investigation. Other committee members voted to overturn the election on the night of the attack. They're now questioning whether the investigation into that attack was legitimate. The defense strategy isn't to dispute the evidence, it's to discredit the investigation, attack the prosecutor's authority, and reframe accountability as partisan overreach. That strategy works only if the underlying facts never get addressed directly, which is why the representative forced them onto the record. What this hearing demonstrates is the gap between what the evidence shows and what the political response has been. The special counsel report concluded that the evidence was sufficient to obtain and sustain a conviction at trial. Trump's advisors, including John Eastman, advocated for violence as necessary to prevent certification of the election. Trump's own attorney general and vice president knew he lost. 60 courts found no evidence of fraud, and 147 Republicans voted to overturn the results anyway. None of those facts are disputed in the hearing. What's disputed is whether the investigation that uncovered them should have been allowed to proceed. That distinction matters because it reveals how accountability gets deflected. When you can't defend the conduct, you attack the investigation. When you can't challenge the evidence, you challenge the investigator's authority. When you participated in the events being investigated, you chair the committee questioning the investigator. The representative's questioning forced a simple acknowledgement. The evidence was sufficient for conviction. The only reason prosecution didn't proceed was Trump's re-election. That means the legal system didn't exonerate Trump. Voters did, by making him immune from prosecution. Whether that immunity extends beyond his presidency, whether state prosecutions proceed, whether any accountability results from an investigation that found sufficient evidence for conviction, those questions remain unresolved. But the evidence itself is now on the congressional record, confirmed by the special counsel under oath, regardless of whether the committee chooses to address it. If this kind of coverage matters to you, hit subscribe.